All right, item number 14, consideration and discussion of NRS 281A, ethics in government, including conflicts of interest and related issues. This item may include a discussion of ownership of irrigation shares by a board member's family or close relatives, and whether such ownership gives rise to a conflict of interest. Rich.
Obviously, I asked for this one to be on too. After our last little coup d'etat, I had some comments made about my mother and father's ownership of water, and that it constituted a conflict of interest. So I asked Bo and his office to research that. I'd asked him before in public meeting whether it was, and his opinion was it wasn't. So I asked him to actually contact the Board of Ethics and ask them for their opinion. So I did that, and maybe Eric can shed some light on that for us.
Yeah, we did communicate with the Ethics Commission regarding the issue as far as whether just the fact that Rich's parents own water rights, or shares rather, and they can make it, whether that in and of itself might cause a conflict of interest with respect to district business or matters that may come before the district. The Ethics Commission didn't express any concern in general about the fact that the parents or Rich's parents own water shares, and we didn't actually use Rich's name in the communication. It was a board member and parents, just kind of general terms, but didn't express concern over the parents of the board member owning water shares. They did indicate that, if matters regarding water rights or something that comes before the board, that any disclosure that might be given to kind of disclose the water rights that are owned by family members might include some additional information to this to kind of fully inform the public of why or why not the decisions that are being made by the board might have an impact or effect on the parents, or the parents' ownership of the shares might influence the decision that's being made. But like I said, just the general fact that they own water rights didn't seem to cause any concern or raise any issues with respect to the Ethics Commission. I kind of defer to the statutory language, which in NRS 281A. 420 kind of governs the conflicts of interest of board members in these sorts of circumstances. And the language focused on matters that might come before the board, and when a board member shouldn't act or vote or abstain from voting on matters. And it, like I say, it uses the word matter, so it's kind of a case-by-case basis based on the information, it's just based on what's coming before the board. And so in the language specifically in subsection 4, or actually rather subsection 3, says that a public officer, which in this case could be Rich, I think, shouldn't vote or advocate for the passage or failure of any matter if his independence of judgment or the independence of judgment of a reasonable person would be affected by things like an acceptance of a gift or his pecuniary interest in something, or his commitment in a private capacity to the interest of another. So that last one, the commitment in the private capacity to the interest of another, would probably be the one most impacted by the fact that his parents own water. So if something's going to come up where a reasonable person would be affected by his parents' ownership interest of the water, then he shouldn't vote in that circumstance. But it goes on to indicate that it must be presumed that the independence of judgment of a reasonable person in the public officer's situation, again Rich, would not be affected by the acceptance of a gift, significant pecuniary interest, or commitment in a private capacity to the interest of another person, where the resulting benefit or detriment accruing to the public officer, or if the public officer has a commitment in a private capacity to the interest of another person, that, and I'll kind of skip the rest, but it just kind of duplicates the language, is not greater than that accruing to any other member of any general business, profession, occupation, or group that is affected by the matter. So what it really boils down to, if the action that's being considered by the board, or the matter that's come before the board, isn't going to have a greater impact on, Rich's parents, or Rich, because of his interest in his parents' ownership of the water rights, isn't going to affect them more than other similarly situated persons, members, other shareholders of the water rights, or other groups they may be a member of. If they're not going to receive, a particular benefit, or it's not going to have a particular harm or detriment to them, then he doesn't have to abstain from voting on that matter. Like I said, I know the language is kind of hard to read, but I wanted to refer back to the statute itself since it covers this. But that's the concern, is the issue before the board going to confer a benefit on someone that's given Rich a gift, or if someone, a business he has a pecuniary interest in, or his parents in this case, who have water rights and are water shareholders. Are they going to be particularly affected by benefit by the board's decision, or are they going to be harmed, or something detrimental to them going to arise from the decision of the board? And if it is, would a reasonable person, would that affect their decision making? That's the consideration that would be made as far as the matters coming before the board.
Now, under point 420, it doesn't, receiving a gift doesn't exclude you from voting on something, but there's not an instance where you shouldn't disclose that, right?
No. In fact, the disclosure should be made if you've received a gift, you've accepted a gift, or if you have a pecuniary interest in something, or in circumstances like if you have a commitment to someone in a private capacity where it could be affected by the matter, then the statutes err on the side of disclosure rather than not disclosing those situations.
Does that include free rounds of golf or severely discounted rounds of golf for you or your family members, i.e. husband? And dinners?
Gift, a gift was basically, and you're testing my memory here on the case law on this, but it can be relatively nominal as far as the gifts. Yeah, and so I'd have to get back to you on the exact dollar figure. I think there is case law that gets into the exact dollar figure as far as when it is. But the language in the statute is if you've accepted a gift or a loan, then you're not supposed to approve or disapprove or abstain from voting on matters that relate to that. Or if you're in a situation where you've accepted a gift or a loan and the fact that you've accepted that gift might affect a reasonable person's judgment in making that decision, then you're supposed to abstain from voting on those issues.
Or at least disclose it.
Well,
You
disclosures,
have to disclose.
yeah, disclosures
Not an option.
should be done regardless, but like I say, if it would affect a reasonable person's judgment in making the decision, then you should abstain from voting in addition to, and go beyond just disclosure of the issue.
I just wanted to make sure that was clear. I've tried very hard not to have conflicts, and nobody's going to sit up here and not have a potential conflict. It happens to everybody. It happened to Sandra the other day when her husband put his name on the list to be included in the possible nomination. So there's nobody that's not going to have a possible conflict of interest up here. I just hope that everybody's adhering to the law and disclosing it when they do. And I plan on doing the same. So.
And while we're talking about it, let me take this a little bit further and say that the language in subsection 4B also goes on to say that because abstention disrupts the normal course of business and can deprive the public and the officers' constituents of a voice in government affairs, says that it's intended to require abstention only in clear cases where the independence of judgment of a reasonable person in the public officer's particular situation would be materially affected by the public officer's acceptance of the gift, et cetera, et cetera. So it kind of makes a point of making clear cases is where abstention should be done.
Thank you. That's all I have.
All right. Any other comments on this item?